Hello, and welcome to another episode of Selling the South. I am Blake Kirsch, a third-generation real estate agent here in the Upstate of South Carolina. My guest today, I would like to tell you how we met, but unfortunately, I don't remember how we met because I was just a couple hours old.
I remembered in great detail.
This guest held me in the hospital. This is my favorite real estate attorney, George Brandt, with HBV Law, Henderson, Brandt, and Veith. They're located in downtown Spartanburg, South Carolina. And for the rest of the episode, you'll hear me call him Buck or Bucko because that's what he goes by. And that's what I've grown up calling him. Buck's partners are Matt Henderson, Josh Henderson, Rick Veith, and Joe Albert, I guess would be.
That's correct. You got it.
Considered a new partner. So yeah, today I'm going to ask Buck some very pertinent questions for a South Carolina real estate attorney. So let's get into it. You ready, Bucko?
I'm ready. Rock and roll.
Anything you want to say before we start?
No, but just how grateful I am to be here with you.
It's like pulling teeth to get on Buck's schedule. He's a busy man, so we're going to get it done. First of all, how long have you been a real estate attorney?
I've been practicing law since October 1st, 1975. So I'm coming up on my 49th year. I think I'll be in my 50th year after that.
And have been a closing attorney for my grandmother, my mom, and me.
And numerous other people.
And two, Buck went to, where did you go to high school?
I went to high school at Rock Hill High.
Rock Hill. And then you went to Wofford College.
Went to Wofford College.
And USC for law school?
University of South Carolina, graduating in 1975.
Wow. That's awesome. And, I think one question that we get a lot more now than we used to get because we have so many people moving here from out of state is why in South Carolina do we have to have a closing attorney? Why do real estate closings take place in an attorney's office instead of, I think in California and places like that, they have special offices just for real estate closings?
Well, that's a good question. I think it might be because our legislature wanted to protect the public by having an attorney oversee all aspects of the real estate closing so that the general public would not be taken advantage of by anyone. All 50 years I've been practicing law, it's been required to have a real estate attorney.
And I think it's best. And, realtors definitely are not attorneys. We're not supposed to write, contracts. We're supposed to, oversee the transaction. But the real estate law questions, we're supposed to refer to an attorney. And thank goodness we have a good one. Why are buyers and sellers allowed to use the same closing attorney? And how is that not a conflict of interest?
Well, one of the forms that we get signed, and one of the things we explained to buyers and sellers at closing, is that we are representing the sellers to prepare certain documents and the buyers to prepare certain documents, but there's also a potential conflict because we're also representing the lender at the closing. So we get a consent signed by the buyer, the seller, and the lender to allow us to have that role to represent all three parties at the closing. If there's ever a dispute between the buyer, the seller, or the lender, we become witnesses and we can't represent any of those parties in any future litigation or dispute.
Have you ever represented a client against their lender in a dispute, or mostly buyers and sellers?
No, we could not.
Okay. Or, well, not one that you did the closing for, but like somebody
other lenders for closings that I've not been involved with, the attorney would refer them to me because I was not involved in the closing, and I could represent them against the lender.
Okay, that makes sense. What is the number one question if you were to get up front with me when I first meet the buyers? What's the number one question you would want the buyers to ask their closing attorney, whether it was you or what would you give them advice? What would they ask?
Well, am I going to get title insurance to ensure the fact that if there is any problem with the title at some future date, that they're completely protected by an insurance policy?
And you kind of just explained it, but how does title insurance work? how do people pay for that, and really what is it?
Title insurance policy is issued by a title insurance company. We represent First American and Chicago Title. There are other good title insurance companies. That's just who we happen to write for. And lenders require it. So the lender is protected, and the buyer can also get what's called an owner's policy. So for instance, if there's a $200,000 sales price and they're only borrowing $150,000, then the lender would get an insurance policy for the $150,000, and the buyer should get one for that $50,000. Plus, they have what's called an inflation rider to it, so that if the problem comes up 5 years later and the property's worth $250,000, lender's loan is paid down, but the buyer will be covered up to the value of the property at the time the problem arose.
That would be very important right now, because houses we sold 6 years ago, we're now selling for twice as much and more.
That is exactly right.
That's very important to know. And I guess the title insurance policy is part of the closing documents they get.
Yes, and it's part of the closing costs. And as I said, it's required by the lender, and it is disclosed prior to the closing ever taking place 3 days in advance.
What is the title search process? Why are buyers and sellers paying attorneys to have a title search, and what does that turn up?
It's unbelievable what it turns up, but the purpose is to make sure that the buyer has what's called fee simple title, with certain exceptions. For instance, the buyer could move into a subdivision that has restrictions, or homeowners association, so that it's disclosed to them. Those are public records, so it's disclosed to them at or prior to the closing, so that they know that they're going to have to pay HOA dues. But the reason we're doing title searches is to make sure that the seller does not have any outstanding liens that we're not paying at closing. They can be state or federal tax liens. They could be mortgages. They could be options to sell. Seems like you find something new every day.
Mm-hmm. We've uncovered some interesting things, I know, when we've had closings together through title searches, but what would be a standout in your mind of the craziest thing you've ever seen on a title search?
Well, the most recent thing is I had a client who bought a piece of property at a tax sale, and after building a $250,000 house on the property, realized that the tax sale had not been done correctly, and that the property actually belonged to someone other than the entity that the tax collector gave the appropriate notice to. So that was the worst thing. But I've also had a similar circumstance where a buyer and seller agreed to buy a piece of property. The buyer bought the property but built the house on an adjacent lot.
On the wrong lot.
On the wrong lot. Fortunately, in that instance, I actually knew well the owner of the other lot, and I was able to persuade them just to switch lots.
Where was that?
That was in Spartanburg.
In Spartanburg?
Mm-hmm.
Oh my gosh. I think another important part that's kind of along those same lines, people always ask me if they think they need a survey for the piece of property they're buying. There's instances where, in my view, that's definitely needed. There is instances where I don't think that's too necessary, like if you're in a new construction neighborhood that has all the stakes out there. But when would you recommend? I mean, you know, I know you're supposed to probably say you always recommend to have a survey, but when are the situations where you usually recommend that?
Title insurance companies used to require surveys prior to every house closing. However, for competitive reasons, one of the larger title insurance companies stopped requiring it and just fed that into the possibility of there being a problem. And now none of the title insurance companies require it, but there are times when we think it is necessary. And that's been if there's been some new construction right beside it, so you know where the lines are. I deal with property line disputes all the time, because there is not a recent survey. I'd always recommend it, but it takes time, and now surveyors are very busy
and expensive,
and it would delay the closing, and rates would expire before the survey could get done. So it's kind of a rare occasion that a survey gets done.
We, there's several situations where we definitely have to do a survey when we have big commercial clients. You and I have had to organize surveys for them. Also, we have so many lakes, and lake property lines are very interesting. On some of the lakes, you have to have a certain amount of lake frontage to be able to put in a dock, things like that. So on those, if somebody's buying a piece of lake property and it doesn't have a dock and they think they're going to get a dock, it's worth having that survey to make sure they have that correct.
And to get permission from the appropriate authorities to put the dock in before, and as you know, it should be contingent on the contract.
Absolutely.
Before it ever gets to that point.
Absolutely. And I think too, we had another situation recently where maybe you should always check your own information before you start litigation against somebody. We had a recent one where one of our clients, they began getting sued because somebody said that their trees were growing over the neighbor's fence. So we had a survey done, and it showed that the neighbor's fence was actually on their property. So they didn't get to have their day in court on their issue. They got turned around on them.
I'm involved in litigation about cutting trees. I have 2 cases right now, and I get calls all the time about it.
Cutting trees
or cutting limbs.
Big, hard-hitting stuff.
Yeah.
What another good question I get a lot, especially from older individuals who
that
would
be like me.
Definitely like you, and people like me should worry about this too. What is the best way if somebody is older and they're expecting, that the house they're buying right now is going to be their last house they buy, or it's their retirement home, or they're just trying to prepare, for end of life? What is the best way to set up their house so that it best transfers to their heirs?
Well, there are a couple of thoughts on it. One, if a person is convinced that it is going to be their last residence and they would like one or more of their children to have the property, they can have the property deeded to them with what's called a life estate, which means at the end of after they die, their children would record their death certificate, and that property would not go through probate. Certain things you need to think about before you do that, though, is do you want to give that authority away so that you can't sell the property anymore without the consent of your children if they're the ones with what's called a remainder interest in the property?
That's almost somebody who definitely can't move again, or this is definitely going to be...
Well, I mean, not necessarily. You just have to think it through and go in with your eyes open. That's all. Another way to consider doing it is, here's another drawback in that. If, for instance, you think it's going to be your last house and you want to leave it, I'm just going to say, and you want your son to have it, your only son to have it, and you do a life estate and give your son a remainder interest, and your son passes away unexpectedly before you do,
then their heirs,
you're dealing with their wife and or children whoever is going to inherit their part of the property. In that instance, I would suggest that whoever had the remainder interest to do a will leaving the property in the event that they do pass away before their parent back to their parent or parents.
Then it would become just they would just have a regular deed title of the house.
Well, then there would be a deed from the estate there. Another way to do it is to deed it with what's called joint tenants with right of survivorship, which would mean that if either party passed away, their interest would go to the other party. It's just always something to think about. That's the reason you need attorneys involved in transaction, to fully explain what the possibilities are in the future so that the client can make informed decisions.
And are those two options mostly to just avoid probate, or are there tax benefits to doing it that way?
Well, if you leave somebody a piece of property with a life estate to the child, it's just like inheriting the child, and the child gets a stepped up basis in the property when the property sells. So if you just deed it to the child, then nothing's paid, and the child would then have a zero basis in the property. You have potential gift tax consequences, and when the property sells, significant tax consequences for long or short-term capital gains.
Capital gains. Speaking of capital gains, I know we do a lot of 1031 exchanges together, and I have always have investors asking me how that works. What is your take on a 1031 exchange, and how do you handle those?
Well, I use a company, Bankers Exchange in Greenville, and they are up on the rules and regulations, which are subject to change
All the
every
time.
change of Congress. So I always tell them to go to Bankers Exchange, and they can be very complex transactions, and get the appropriate documentation so that there is no confusion about it when the time comes. I just had a recent closing where the seller came in and said, okay, well, this is going to be an exchange. He had never contacted the exchange company.
He just thought
and the deal did not go through because he really didn't understand.
What is a 1031 exchange for people who?
It is an opportunity for a seller to sell a piece of property, put the proceeds with what's called a qualified intermediary, and then have a specified period of time to reinvest those monies in a similar property without getting taxed on it. Instead of selling it, getting taxed, paying a long-term capital gain, losing that percentage of the money, and then going and buying another percent. Let you use 100% of your net profits.
Rolling into another investment property.
Yes.
And I think a lot of people are interested in that. And another question that I have to explain very often, we walk all of our clients through what their closing costs are going to be. And one of the most, interesting closing costs that I don't even fully grasp myself on where this money goes is deed stamps. What are deed stamps, and how do we calculate
Deed
them?
stamps are, it's in effect a tax charged by the county to record the deed. It's $3.70 a thousand, paid by the seller unless it's agreed to differently in the contract, which it can be. So on a $100,000 sale, the seller is paying $370 to the county so that the deed can be recorded. It is a way of funding the Register of Deeds office and other county activities, I suppose.
They make a lot of money nowadays with as many houses as we have. So
with inflation, you're correct.
yes, their revenue definitely is going up.
Yeah,
With the market,
but the cost has too.
the cost has as well. My other question is kind of back towards the different ways of deeding your house and what kind of title you should take with your house. What benefit is it to, say, just a regular buyer, first-time home buyer buying a $300,000 house? What benefit do they have for putting their house in a trust or an LLC? Is there any benefit? And then when would you recommend somebody use a trust or an LLC?
Well, I always tell people to seek the advice of their CPA before you do a trust. But the purpose of the trust is to put your assets in there, avoid potential litigation against individuals, and to avoid probate.
Oh.
That's to me what the purpose of it is.
And an LLC, when would you recommend somebody put their property in an LLC?
If it's an LLC, you would want to do that potentially if you would never do it as an individual unless you had, I don't know, significant judgments against
Something
you.
to hide.
Well, just to keep there being a lien placed against the property, because if you're an individual, you can get, which an owner-occupied rate on the taxes, which is significantly less than what it would be if you placed it in an LLC.
That's a good point too to bring up. And one of my next guests soon is going to be the county auditor in Spartanburg, Sharon West, to talk about property taxes. But one of the most important things you share at closings is about how people can avoid a 6% tax rate on their personal property. How they can do a 4% tax rate.
Well, I feel so strongly about it. I mean, a lot of attorneys don't do it, but I get the form and fill it out for them and instruct the client that they must do it. I did it today with a young lady who was buying her first house. Her license was going to expire on September 1st. I made her go that day, filled out the form for her so she can go and file it and get the lower tax rate, which is as much as 3 times more if you fail to do that.
Yeah, and I know why you're passionate about it, because you've seen and I've seen clients that we've told until we're blue in the face to go do that, not do it, and then come to us and say, why is my tax bill $9,000 instead of $3,000?
And I'll tell them to go look in their file, and they will have a 4% form that I filled out for them. I think the county would give them 1 year back if they could prove that they moved in the prior year before that big tax bill came out. But
that's a hassle.
That's up to them.
That's a hassle to do too.
And subject to change.
One important form that we have all of our clients sign on the buying and the selling side when we do a contract is a wire fraud warning form. I know you've dealt with your share of wire fraud issues. How would you warn people against wiring money when they're doing a real estate transaction?
The most important thing is to confirm that the wiring instructions are correct. For instance, someone's getting my wire to wire transfer money to me, I will send them the form. I would prefer to fax it, but I will send it without any reference to wires. I would recommend that they call my office in a number that's not on my instructions, to go to the internet and get my law firm's telephone number, call and speak to someone in my law firm, and get their name and confirm that the wire instructions are correct. We have significant wire fraud issues almost on a daily basis with payoffs, with forwarding funds from buyers to sellers, with out-of-state sellers who aren't really the owners of the property.
Even our county got hacked last year and it messed up our closings.
Well, we had a lot of problems last year with our county having a internet attack on the county that shut the county down for a month. So
we've had a lot of computer issues that kind of, was this like this?
But we all do every day. I mean, we really do.
When you first started doing real estate transactions, did you often have people bring cash money into the office for closings, or just checks? Or
yes, but that was back in the day.
Real back in the day.
I don't like cash now.
I wouldn't mind it if somebody brought me cash.
If it's over $10,000, I've got to fill out a report with the bank, and the bank can come ask me about it. So I would prefer a wire transfer or a cashier's check.
Or a cashier's check. Another good question kind of about security would be, in a real estate transaction, most of the time we do have earnest money that the buyer will put down at the beginning of the transaction to show the seller their earnest, and also to kind of secure the property until the closing. Usually that money goes towards the buyer side of the closing at the closing. Who holds that money between the contract and the closing is up to the buyer or the seller, or both. Real estate companies can hold it in an escrow account. The way I do it is my closing attorney always holds earnest money. What is an escrow account, and how are those monies managed?
Well, an escrow account, we were required by law to have them. It cannot earn interest. We take other people's money, put them in our account. We have to balance our account. One of the problems that you kind of alluded to there is where there will be a real estate transaction. The buyer places money in our escrow account to bind the contract, and then the transaction does not close, and the buyer wants the money back, but the seller wants the money because the seller believes that the buyer breached the contract and we're stuck in the middle. There's an arbitration clause in the South Carolina real estate contract that typically takes care of the problem. If there's a contract that's not the South Carolina real estate contract, then we would pay it into the clerk of court's office. We'd have to do an interpleader, let them
Whole
fight
thing.
about it. It's very expensive.
Most people don't do that. Most people move on.
Most of the time people reach an agreement, but occasionally the buyer gets sufficiently mad at the seller and the seller gets sufficiently mad at the buyer.
And they spend more money trying to
Spend
work
more
it
money
out.
trying to fight over that $2,500 than that $2,500.
Well, another thing that's complicated that a little bit in the last couple of years has been the introduction of this termination fee, which is a separate monies, or supposed to be a separate monies from the earnest money. A fee that if you were to back out during the due diligence period, you would forfeit that to the seller. I've run into several occasions where we're trying to get that money to the seller, where the contract hasn't even been really ratified and the seller wants that money. There's so many things with the termination fee. I think usually the realtor ends up having to deal with that because it's usually small.
Isn't it great to have lawyers, Blake?
It's great to have lawyers.
Deal with those problems.
I know. I don't like to
And
deal
the
with.
many others problems.
Thank goodness. How often do I call you with the biggest problem in the world and you work it out for me?
With some frequency, and it's always good. I mean, you make a good point. I think it is a great idea to try to address problems on the front end instead of getting close to the closing, the scheduled closing, and then trying to address the problems.
Yes, I think that's what really sets apart like a seasoned realtor and a seasoned team from somebody who's just getting started. You can kind of get overwhelmed with all your transactions and then get close to the closing and try to finish everything up. But really, you need to do and my mom is the number one person who taught me this, you need to do everything as much as you can up front in that first day and those first couple days, because there's so many things that'll pop up between contract and closing.
It's really unbelievable. Here's another, I did want to discuss one more issue that you probably have on your list of questions. And that is when somebody passes away and the heirs want to sell the property. And that's something that you as a realtor oftentimes face. And you need to get those folks to the probate court or get them to an attorney who can get them to open an estate. You and I had a transaction this year with personal representatives of the estate.
One lived in Kansas, one lived in New York.
Yeah, and then one moved to Africa.
Yeah, Africa.
To complicate the problem that much.
In the middle of the transaction.
And if there is not a will, then a lawsuit has to be brought in the probate court to get the authority to sell the property and to appoint the personal representative and authorize that person to sign the deed and the closing document. And it's complicated by many things, one of which is the difficulty of scheduling in the probate court because they are overwhelmed.
And one thing I want to say, since we bring that up, is, realtors and attorneys are two of the least trusted, professions in the world by all these studies I get thrown at me all the time. And that example is one that I think is a good combat for that. We ran into these clients who inherited over $1 million worth of real estate, and they were almost in tax sale. They did not know how to do probate. They had not received adequate help from an attorney or from a realtor. And I just stumbled across it and said, these girls need help. And within a few days, the girls and I met. We got the help of Buck and the people in his office, and ended up, the girls got to sell 2 pieces of property, keep their family home, make a good bit of money, and do it all remotely pretty much from different states. So I know we don't speak very much on specific transactions, but I will say that sometimes the help of an attorney and a realtor working together can make all the difference for some people.
Absolutely. Another case I had with similar problems was that the father passed away, leaving property to two children who did not get along, one out of state, one in state, and the property went into foreclosure. So we had to hurry up to get the estate opened, getting together the two children who did not speak, getting them to agree, getting someone appointed personal representative, getting the authority to close. Otherwise, they would have lost a significant amount of equity in the property just by ignoring the problem.
Sometimes in a business transaction, you have to have somebody who's emotionally removed. And obviously, we deal with tons of divorce situations and complicated family situations. And, being emotionally detached from that, we can help them make a lot of money and save a lot of money by looking out just for their best interest instead of getting upset or,
Absolutely.
taking a side.
Yeah.
How's that?
But we get upset too sometimes when they don't take our advice.
Not at each other. We don't get upset at each other.
No, not at each other.
Bucko is, if you're not from Spartanburg, Bucko is definitely an institution in Spartanburg, somebody that everybody loves, has an amazing family, an amazing wife, wonderful kids.
I just celebrated my 50th wedding anniversary Saturday.
Oh my gosh. And his wife's name is Mary Nell.
That's right.
And she's awesome. And he has, how many grandchildren?
6 grandchildren, 4 children.
6 grandchildren and 4 children. And, they're all amazing in their own right. Buck, what is your favorite part about living in the upstate of South Carolina?
The people. I mean, it's great. A lot of people don't like my job, their job. I love my job. I love coming to work every day, dealing with people like you and the people you bring to my office, and that many other people like you who are realtors and non-realtors who bring people to my office. And I get to meet them, interact with them, and interact with all the people in Spartanburg. What a great place to live.
I think the best part about coming into a closing at your office is you kind of make the experience. A closing, to a large extent is kind of an experience for the buyer that they're just, it's something that they can remember, and you make it so awesome because you're fun and you're entertaining. And, they just love being there with you. What is your favorite part about being a closing attorney?
Well, for instance, today I had a first-time home buyer who was 20 years old, was not going to be 21 for another 6 days.
Wow.
And helping her experience that. She was buying a $271,000 house. My first house was $23,500 at that age. So it's just a great experience getting to meet people. Welcomed into Spartanburg. There are a lot of people from out of state coming to live in this area because the quality of life is so wonderful.
Are there any upcoming or anything from this year that would be like a new real estate law that you're concerned about, or anything in the news that we should know about?
Well, I'm most concerned at the moment with the new real estate law concerning
NAR.
Yes, all of the changes that have been experienced.
Okay, moving on. We're gonna.
No, another law that has come to pass, that is the new wholesaling law in this state, and I just took a seminar on that. I don't know if that would affect your clients. I don't believe it would, but it could. But it's complicated. Prior to this law, if you signed a contract to buy a piece of property, you could immediately start advertising to sell that property, to flip it, and either have a simultaneous closing same day or try to assign the contract so somebody else can buy it. If I understand the new wholesale law correctly, if you sign a contract to buy the property, you can advertise the sale of the contract, but you cannot advertise anything about the property other than what is on the face of the contract
until it closes.
Trying to
first
sell.
one.
Mm-hmm. And if you want to buy it and flip it, now you need to buy it, put it in your name, then you can start advertising. You have to own it.
one important thing, I think probably the most important thing between realtors and their closing attorneys, we learn from each other all the time. We bring them new cases that we have to work through together. And then the next time something like that arises, we can, we know the answers.
Always something different, though.
It's always something different. And that's why for a young agent like me, it's invaluable to have, obviously my mom, my grand, but also Buck that's so experienced, and, his staff that's so experienced. Buck, to end the show, I always like to bring up a nonprofit that we're passionate about, somebody that my guest is passionate about. What would be the nonprofit that you'd want to
The nonprofit that I'm on the board of Ballet Spartanburg and have been for several years. It is a wonderful organization, and it brings life to Spartanburg, South Carolina. More and more people should attend, and that's my number one.
My mom told me yesterday, we were discussing your youngest, newest attorney, Joe Albert, saying how much we like him and saying that he'll likely be my closing attorney one day. And Mama said the words, when Buck retires. I'd never given consideration to that.
Well, why don't you just say when Buck dies? Because I have no plans to retire.
I don't think you should. I think you're more spry than every other real estate attorney, most of the real estate attorneys I work with. And I'll tell you, I think you and my grand are in that same boat. You'll be happier sitting at your desk than anywhere else.
Happier helping people.
Yes.
You're correct.
And y'all do a great job of it. Buck, thank you so much for doing this with me.
Thrilled to do it.
And we'll do it again sometime soon. Guys, thank you so much for joining another episode of Selling the South. I'm Blake Kirsch. Have a great day.